going to go through the different parts of each of the plaintiff's motion and the defendant's motion and the plaintiff's response. So I'll announce which things I want the parties to redact, and then, I guess, refile it. I am going to say a couple things that this little process, I don't know how long I was in there, but I'm not doing this on a regular basis. It's impossible. I think that the several things under the rule 2.420 C9. If you look at A1, confidentiality is required to prevent a serious and imminent threat to the fair, impartial, and orderly administration of justice. For the court to review all of the pleadings, one, I think it has a chilling effect on the creative writing of the attorneys and preparing these pleadings in the first part. I appreciate the fact that one side wants it to be sealed, the other side wants it not to be sealed. But within there lies an inherent conflict in a writing style. And the ways that words can be twisted, misrepresented, said in such a way as to create suspicion. And I think it goes directly to the orderly administration of justice, which that's what this whole trial is about. So I think that the way that I ordered this provides somewhat of a way to show what the parties have been going through, but on the other hand, in accordance to 9.6, it avoids substantial injury to a party by disclosure of matters protected by a common law or privacy right not generally inherent in the specific type of proceedings sought to be closed. So, a little of this is by avoiding substantial injury, a little of the part that I've blocked out, avoid substantial injury to innocent third parties. Most of the folks that have been mentioned have already been there, or are already, their names are already out, so I don't know if they're innocent third parties. And some of it is according to obtaining evidence to determine legal issues in the case. I think it's important to allow this discovery, like I said before, but a lot of it just really isn't. Because of those rules, I decided isn't coming in. So let's go. If everybody can have their copy of their motion, the motion and the response, and we'll go through that. Mr. Berry, have a copy of it with you there?
Yes, Your Honor. You started with this one.
I'm starting with the motion to dismiss for fraud. That's the only one I'm addressing. And the response. Okay? So what I'll tell you will be redacted out. Go to page 2. The first full paragraph where it starts with first, and the remainder of that page is out. Okay. Go to page 3. From the top of the page, all the way down till that paragraph that begins while Belea, all of that top part is out. The paragraph beginning while Belea is in. Page 4.
Judge, by the top part, you mean the two paragraphs preceding the bubble?
Yes, that's all. So on page 4, beginning with factual background, for the rest of that page is out. I'm not seeing anybody draw any lines. Okay.
Your Honor,
yes.
Sorry, I'm just perplexed with, just for example, the stuff on page 4 talks about...
Right, I'm not going to go through all the details of it. So I'm sorry that you're perplexed, but I'm going to announce this and you'll just have to figure it all out. I don't know.
Well, how is it possible, Your Honor, the things that are public, the things that are here are published in newspapers? How is that?
Mr. Berlin, please sit down or strike from factual background down. On page 5, the top part of the page is stricken or redacted, and then it's beginning with number 2. That part stays in, and in fact, the footnote can stay in. On page 6, beginning with paragraph 3, number 3, Balea and his counsel, that part is redacted from the bottom of the page, top page is in, not redacted. Page 7, the whole page is redacted. Page 8, the whole page is redacted. Page 9, from the top of the page down to the paragraph that begins in short. So the paragraph that begins in short is in, or not redacted. The top part is redacted, and the footnote is redacted. Page 10 is redacted. Page 11, redacted. Page 12. Paragraph 3, or number 3 at the top is not redacted. There are 3 lines that begin during the same period and ending with 4 instance. That is redacted. And footnote 5 is redacted. Page 13, number 5 is redacted, number 6 is redacted, and the bottom of that page, beginning the last 2 lines that beginning with Exhibit 31 and ending with audio, those line and a half is redacted. Page 14, redacted. Page 15, redacted.
Can I just clarify? Going back on these pages where the full page is redacted, that includes the footnote portion?
Yes. Unless I say something. Number 16 is redacted. 17 is redacted. On page 18, the top 3.5 lines are redacted, and paragraph 14 at the bottom, 4 lines are redacted. Page 19, redacted. Page 20, redacted. Page 21 redacted. On page 22, just the top 3 lines are redacted. 2.5 lines. On page 24, all of page 24 is redacted. And on page 25, the top part is redacted, stopping that these communications remains in. So the indented part is redacted. But these communications and the remainder of the page is not redacted. Are you with me, Mr. Bailey?
Yes, sir.
Going to page 31.
Judge, was the balance of 25 in starting at paragraph 3?
Yes. Well, not starting at paragraph 3, starting at these communications.
Yeah, I mean the
That's
balance.
in, and then the balance of that page is in. Now go to page 31. paragraph beginning with Houston and the ending of that paragraph to statements is redacted. So that whole long paragraph is redacted. And that's it for that resolution. Okay, let's go to the response. So page 8, beginning with Gawker, including the footnote, are redacted to the bottom half of the page. Mr. Beard, you have a copy?
I don't. I got it while traveling yesterday, so I just have an electronic version.
I have a copy, Your Honor, so I'm working for us.
Thank you, Mr. Beard.
We'll be good. Thank you. Thank you. I'm sorry.
That's okay. Page 8, beginning with Gawker and defendant.
Thank you.
The remainder of that page. I figured Mr. Beard would describe it that way.
It's a dangerous assumption.
Page
We
9.
all try and describe the office. Thank you for making sure we're good. Appreciate it.
Page 9, the top of the page until C, all that is redacted.
So,
Go to page 19. Starting with second, Gawker. So that second full paragraph and the remainder of that page is redacted. And the top of page 20, that first paragraph, beginning with the remaining and ending in that light, that paragraph is redacted. Page 21, the first full paragraph beginning with the linchpin, and going to the middle of the next paragraph. So the part that is redacted is the fourth line in the beginning of the paragraph that begins Gawker to the word Davidson. That portion is redacted. So the part that is not redacted begins the privilege covers. That is not redacted. And the last two lines, not of the footnote, but beginning with Mr. Balea and ending with the D, is redacted. Those last two lines are redacted.
I'm sorry, what was the last one, Your Honor?
So on that page 21, the last two lines, but not the footnote. The footnote is not redacted. Beginning with Mr. Balea and ending with D. Those two lines are redacted. And then the top of the next page. So the first over a half a page and the top is redacted. So where the paragraph that begins Gawker defendants remains in, but the rest of the top of that page is redacted. Page 26. That whole page is redacted. Page 27, the first three lines are redacted. And that concludes that portion of it. So if anyone would like not to re-argue, but clarification of what is redacted, you're certainly welcome to look at my copies of it at a break. Okay, so I think that deals with the confidentiality aspect of it. I hope that you all can make heads or tails and hopefully some consistency out of it. We'll see where we go.
May I ask one question? With refiling these in redacted form, the exhibits that are cited within the redacted...
None of the exhibits. I'm not going through the exhibits.
So those are to remain under seal, it's just the briefs?
Yes, it's just the briefs.
Okay.
That it gives Ms. Field and the client the opportunity to see basically the gist of what's being argued and the legal arguments framing them. Oftentimes, the factual content is interwoven into the legal argument, and so I think that I've been consistent. My hope is to have been consistent with certain portions of it remaining out that are to avoid substantial injury to a party by disclosure of matters protected under 6, or to prevent a serious and imminent threat to the fair and partial and orderly administration of justice. But that one provision is primarily in this exercise of going through all the different things.
Okay, I just want to make sure we're on the same page.
I understand.
Thank you.
I didn't get to do a re-argument. All right, anything else before we go to the heart of the motion? Ms. Steele, do you have anything else before we go to the heart of the motion?
No, it's on your own. Thank you.
Okay, thank you. Let's go to the motion.
Well, I'm really not sure now how to proceed because it's my hope that more of this would have been open, and I have a presentation that will bridge both things that you now have made public and things that you have not.
Do you want us to take a break so you can sort that out?
No, Your Honor, I don't. And the reason why I don't is because I think I'm entitled to make that presentation in its original form. And you'll have to decide whether or not you want to do that in open court or not. But the law...
I don't think that's true. I'm sorry, sir. If you're bringing in a demonstrative evidence, or demonstrative aid,
it's not
for your presentation, you've made a full presentation in writing that I reviewed it all. So if you're trying to make demonstrative aid for other purposes, I don't think that that's necessary. And I don't think it's necessary for me to close the court so you can present your demonstrative aid.
I think you're misunderstanding what I'm saying, Your Honor.
Okay.
I do have a demonstrative presentation in the form of a PowerPoint. But even without that, if I'm just standing at the podium, I want to be able to argue not just sort of half the piece. And in particular...
It's way more than half.
Well, here's the problem, Your Honor. This motion was filed about a month ago. The opposition was filed yesterday morning. So there's a number of things that we have to say that are responding to the opposition that we could have done in writing, which obviously since yesterday morning we were all traveling here, we were not able to do. And we need to be able to do that. And the law, in particular on fraud in the court, is that the moving party is entitled to present their evidence to the court. Now, I don't think that means just present some of the evidence. I think they need to be able to make that presentation. I'm not talking about the PowerPoint. Whether I'm standing there saying the things or they're up on the screen, I think is not the deciding factor. But I do think we need to be able to do that, and I'm not sure now how you would like us to proceed.
Judge, certainly I didn't have any anticipation of how we were going to proceed today vis-a-vis confidentiality. I can assure you this. Whether we went through the exercise we just went through or not, our argument was short. And very short because this has all been briefed. And it hasn't just been briefed once. It's not the first time these issues have darkened this courtroom's halls. This is essentially, and we've briefed this before and we'll brief it again, the re-argument of an issue that Judge Case denied on a similar motion for sanctions. And I was there, and I remember it, and I remember thinking about the cases that are involved, Cozell versus Ostendorf and its progeny, and waiting till Mr. Berlin was done at that time with what was about an hour and a half to 2 hours of argument. It was resulting in I think, that motion being denied by Judge Case in about 1 minute. My point is this, Judge. And I want this for the record because I think it dovetails with the exercise you've gone through and some of the comments that have been made. Given the numerous rulings that have been made about some of the content of the issue, given the fact that they've been brought up in a previous motion for sanctions which has been denied, given the fact that they've been brought up and ruled upon as irrelevant trial evidence, given the fact that we have had to, on numerous occasions, come to you and say, Judge, everything they're trying to do when they do this is to eviscerate or circumvent a protective order by dumping 4 boxes of stuff into the record and then challenging the court to adhere to an order that we've been operating by for the life of this case. From our perspective, this is a fairly easy exercise. The papers are very clear. I have a couple of statements I want to make, so if anybody reads this record, they understand the synthesis between what's been done in the past and what's been going on now. But from our perspective, this thing is really nothing more than another attempt to try and get out into the public, outside of this trial and outside of the precise issue, which I will say again has not changed. That issue is quite simple. Whether when Gawker chose to publish an excerpt of a sex video of my client, knowing it to be surreptitiously recorded without my client's consent, was that an invasion of his privacy, or is it somehow protected by the First Amendment when the accompanying narrative was nothing more than a salacious narrative of the sex tape? All of this has nothing to do with it. It dovetails into the fraud on the court cases. I don't see any need for much argument on it, and certainly not a PowerPoint that they want to put up that would, likely implicate any number of the redacted portions that we just went through. That's our position. It hasn't changed any time this has been brought up. So.
I think the case has changed certainly since 2013. There have been a number of new issues that have come in that potentially could have addressed the defenses, which is why I allowed the defense to look through some of that information or to gather some of that information. However, though, whether it changes some of my rulings from the motions in limine that we went through, the time that we spent prior to the hopeful inception of the trial last July, I don't know that that really changes any of that. So I think from the basic standpoint, yes, the defense has been able to look into a number of different issues, or from an issue of fraud on the court. I don't know that any of those same issues that I have ruled on in the past, I don't know that they changed, I don't think they changed my position just in reading the written brief issues from the defense. I don't know that they changed my position from prior rulings. Your Honor, that helps you in Mr. Berlin. I don't know what you intend to do. So.
Well, Your Honor, I actually intend to respond to the argument that Mr. Trikel is making and to explain to you why the materials that we have gotten recently, since those rulings, materials that we got only in the last day of November and the beginning of December, changed things. But it is impossible to explain that in detail in a way that would in any way be persuasive while trying to not touch on any of the pages of the briefs and so forth that you've left as to be redacted and not public, which leaves us in a situation. Look, my own view about this, and I've expressed this, I'm not trying to, Mr. Trikel's accusing us of dumping stuff in the court record. The better part of this case, all sorts of things have been sealed, right? And the unsealing effort by us has been only after those things that we understood he wanted to keep confidential became public. That was how this has gone. This is not, that's the way this has gone. So at this point, right, we have a situation where it's our belief that the stuff is in fact public, and because it's public, there's not a privacy interest to be protected because it's public. Your Honor made rulings. We're not going to go over that again. You made clear that not to re-argue. I respect that. And I hear Ms. Steele saying we want to be able to participate, know what's going on, watch the hearing, and so forth. But from my client's point of view, we need to be able to answer the question that Mr. Trikel raised, which is, what is new since Judge Case ruled in 2014, in the middle of 2014, we're now a year and a half later. And there's a lot that's new. And I'm happy to explain it to you, but I can't do it because it's all been designated as confidential, and much of it now, on that basis, has been basically designated as stuff that is not something that should be public. And so we need to find a way, I think, to be able to present that argument, including to respond to the arguments that Mr. Trikel made this morning and made yesterday, And maybe part of it is to be part of this public, and you'll have to accept it if you believe that this stuff is properly sealed, to accept the profit from us of what we would say beyond that.
So here's what I would suggest to you. Under the Administrative Order 2015-556, it says that a court can rule on non-evidentiary motions based on the written pleadings as opposed to oral arguments. So I've reviewed all of the written stuff already. If you felt that you wanted to supplement a response because of the timing of the plaintiff's response, I think you can certainly do that. But I don't know how to advise you otherwise, because I don't know what you're going to say other than what you have in writing.
My understanding of the law in this area is that we are entitled to make and to argue to you at a hearing and make a factual showing and to discuss those facts. And so that is what I am prepared to do today and would like to do today. And I would like to do it in a way that allows me to actually answer. Right, Mr. Jekyll is basically saying, look, this is all, we discussed this in 2013, we discussed this in 2014.
Both of you are great advocates, and I appreciate that. Both of you have your own views of the case, and I appreciate that. And I think that I have the ability to sort through some of that.
Your Honor, with respect, I completely agree, but you can't sort through an argument that you can't hear. So I need to be able to make that argument.
I don't know what you're saying.
Well, I'm happy to take a recess of a couple of minutes and consult with my team and see if we can come up with some way to proceed.
Okay, great. We'll take a break. 10 minutes. Do you need more than that?
I don't think so, Your Honor.
Okay, thank you.
All rise. Court is recessed for 10 minutes.
There's a lot of ways. It's an argument. Hold on, I'll tell you. It's 30.